Ready when you are.
It's your show and the recording has begun.
Well, welcome everybody to the North Carolina Real Estate Commission's webinar on the new Working with Real Estate Agent disclosure form. We really appreciate you attending this webinar. My name is Steve Fussell. I'm one of the presenters today, along with Janet Thorin and Deb Carpenter. Corinne Hamlin was gracious enough to create this lovely PowerPoint and is working to make sure that this event goes off smoothly. I'd like to preface this webinar by saying, of course, that the Real Estate Commission is a consumer protection agency. And just as it shows at the top of your screen here, our mission is to protect the public interest in real estate brokerage transactions. And one of the issues that comes up regularly is the issue of consumer knowledge. And before consumers share confidential information with brokers, they need to know whether the brokers represent them, because sharing confidential information with brokers who do not represent them could certainly adversely affect the consumer's bargaining position and make it difficult for those consumers to negotiate good deals for themselves. So I'd like to transition into the learning objectives for today. And so by the end of this presentation, you should be able to identify the key points of Commission Rule A104C. That's the rule that requires agency disclosure, and describe the reason for the Commission's decision to change the disclosure form, and to identify key components of the new disclosure form, and to be aware of what happened or what is happening with the old brochure that you've been using for a period of time, and also to explain how the license exam will be impacted by this document change. We understand you're going to have some questions, and we appreciate those. If you want to post those questions in the chat box, we will endeavor to answer as many of those as we can during the presentation. There will be a Q&A session afterward. I'm hopeful that we will have 30 to 40 minutes of Q&A time after that, after we finish the presentation. So I expect that'll be enough time to answer your questions. If you're like me, if you're busy writing questions and fixing typos, you might miss something that you would like to hear. So your best course might be to jot down a question and wait until the Q&A session. But if you don't feel like you can wait, then by all means, put your questions in the chat box. And as I said, we will do our best to answer those questions as we go along. We do want Janet to tell you a little bit about Rule A104C and how it impacts you in your compliance with the license law.
I do not see that Janet has joined us, so I'm happy to jump in, or if you want to go ahead with the rule.
I will be glad to go ahead and do it. Commission Rule A104C requires that you deliver the Working with Real Estate Agent disclosure form to prospective buyers and sellers at first substantial contact, and make sure that you give a copy of that signed form to them within 3 days. This is all about making sure that consumers understand whether the brokers they're communicating with are actually representing them. And you will notice that the rule does require that brokers review the form with the consumer. It is not sufficient to simply include a link in an email to the consumer. It is not sufficient to simply send the form as an attachment to an email. You actually need to review the form with the consumer to better ensure that the consumer understands about agency relationships. All right, so why is the Commission changing the form at this point? The Consumer Federation of America conducted a research project a couple of years ago, and in that they evaluated the agency disclosure requirements and documents used in every state. And then in January of 2020, they published a report that showed the deficiencies in the agency disclosure process of the various states. And those deficiencies included that consumers were not receiving state mandated agency disclosure forms, or that the consumers didn't know they had received the disclosures. And by that, I mean that the brokers were either sending the disclosure forms in a package of documents so that the consumer didn't know they had gotten a disclosure form, or that the brokers were not sending them at all. Another defect or deficiency was that the consumers were signing the agency disclosure forms without reading them, because the brokers were saying, you know, it's required by law, so just sign it so we can move on. And then lastly, there were consumers who really made a real attempt to review the agency disclosure forms and just couldn't understand them because of the complex legal language in those forms. And this resulting lack of knowledge put consumers at risk for sharing confidential information with brokers who don't represent them, and which can cost consumers lots of money. And based on the wording of this report, it appeared to us that the North Carolina Real Estate Commission's disclosure form ranked somewhere in the middle. It had some good things, but it also was lacking in a couple of areas. Of course, those of you who have been around since the 90s know that the Working with Real Estate Agent brochure was first published about 25 years ago. And it still contained good information, but it just wasn't presented in the best format for today's consumer. And the Consumer Federation report indicated that agency disclosure forms can be improved, and they provided a list of recommendations for improving those forms. And so, of course, not wanting to be in the middle of the pack, our Real Estate Commission decided to go ahead and make some changes. And so we've come up with a one-page form, double-sided, where one page is for the sellers, one page is for buyers. If you don't have a copy of the form in front of you, you can find it on the Commission's website in ncrec.gov under Publications. You actually have to go to the Publications tab and then go down to click on Publications, and then go to Disclosure Forms. And it's one of the 3 disclosure forms on the website. I'll give you a few seconds to find that if you don't already have it up. You know, the key factor is that, as I mentioned, there are 2 pages. One page is for sellers, one page for buyers. So when you're reviewing the form with a potential client, you've only got to review one side of the form. You know, but if you have a client, seller, who says, well, I want to sell and buy, or if a buyer calls you and says, you know, I want to buy something, but I also have a property to sell, you can use one form for both transactions. You just need to make sure that you save that document in both transaction files. So in other words, for your listing file and your buyer file, you need to have a copy of this form in both files. And this new form is replacing the old Working with Real Estate Agent brochure that's been in use for the 25 years. The new form is designed to be quick and simple for you to use and explain, and much easier for buyers and sellers to understand. We've intentionally used very basic, simple wording to improve the comprehension of buyers and sellers. So I wanted to sort of take an overview of the seller side of the form. You'll notice at the top of the form, there's a notice that says that this form is to be used in all commercial and residential sales transactions. So this is not just a residential form, it's for all residential and commercial sales transactions. This particular side of the form is for sellers. And below that is an important notes section that we'll cover in detail in a moment. And so we'll be coming back to that. Then below that, you've got a section with 4 different types of agency relationships that could apply to a particular seller. And we'll go into those in more detail in a minute as well. Below the agency types, there's a note to the seller that you're communicating with, basically to tell the seller that if the seller wants more information about agency relationships or the services that you would provide as a broker, or your duties as a broker to that seller, the seller can refer to a Q&A brochure either on the Commission's website, or they can get a copy of that Q&A brochure from you. And then below that, you'll see there are signature spaces for the seller to sign and the date. It's important that you request the seller to sign this as proof that you actually delivered it to the seller. The date on the form should be the date that the seller actually signed it. No backdating or forward dating, just the actual date that the seller signed it. And then lastly, on this side of the form, you want to make sure you print your name on the form along with your license number and the name of your firm. So we're going to take a closer look now at the important notes section on the seller side. And, you know, we understand that whenever you meet a potential seller for the first time, you know, they might be reluctant to sign anything until they get to know you better. And that's why the first note in this section is this form is not a contract. Signing this form only means that you've received it. And that's to take some of the pressure off of you and to hopefully relax the seller into understanding that this form is just for informational purposes. It does not obligate the seller to do anything. It doesn't tie the seller to you in any way. This is just education for the seller. This form also highlights very important information for the seller to understand. Says in a real estate sales transaction, it's important for you, the seller, to understand whether an agent represents you. And says real estate agents are required to review this form with you at first substantial contact. It defines what that means by saying that before the seller gives or receives, before the broker receives any confidential information from the seller, the broker is required to review this form with the seller and give a copy of that form to the seller after the seller signs it. And then lastly, it cautions the seller not to share any confidential information with the agent or assume that the agent is acting on behalf of the seller until the seller enters into a written agency agreement with that agent. Otherwise, any information, any confidential information that the broker receives could be shared with other folks. We're going to take a closer look at the types of agency relationships. And you'll notice at the top of this section, it says note to agent, check all relationship types below that may apply to this seller. And this is for you as a broker to identify the agency services that your company might provide to this particular seller. It's not a selection form. It's not, the seller's not selecting anything. It's just part of your explanation of types of agency relationships to the seller. So let's say, for example, in the first category, you've got a seller who wants to sell. You're hoping to list this property on behalf of your firm. And so what this form is saying to the seller is the agent who gave you this form and the agent's firm must enter into a written listing agreement with you before they begin to market your property. If you sign the listing agreement with the listing firm, then the firm and the agents would represent you. The buyer would either be represented by an agent affiliated with a different firm or be unrepresented. And this is a situation where your firm would only represent the seller, and any buyer involved would be represented either by another firm or be unrepresented. Now, realistically, most firms these days represent buyers and sellers. And so, of course, you would want to tell the seller, our firm also represents buyers. And that's why this form then says under dual agency will occur if your listing firm has a buyer client who wants to purchase your property. If you agree in a written agency agreement, the real estate firm and any agent with the firm would be permitted to represent you and the buyer at the same time. And then it goes on to educate the seller in understanding that a dual agent's loyalty will be divided between the seller and the buyer, but the firm and its agents must treat both sides fairly and equally and cannot help one side gain an advantage over the other side. Now, you're going to have some sellers who are a little bit hesitant about dual agency because of this divided loyalty issue. And if your firm offers designated dual agency, then you can then progress to that type of agency relationship and say, look, if you agree in a written agency agreement, our real estate firm would represent both you and the buyer, but our firm could designate one agent to represent you and a different agent to represent the buyer. And in that case, each designated agent would be loyal only to their client. So this helps create some separation between the two agents, so that each client, the buyer and the seller, would have their designated agent, but the firm continues to represent both parties. The fourth category under agency types involves a seller who is not represented. So in this situation, you would be a buyer agent. So you've got a buyer agency agreement with a buyer. You've got a seller who's not represented. It's a for sale by owner type of deal. And so you're communicating with the seller and explain to the seller that that you will not be representing the seller, and of course have no loyalty to the seller. And it says to the seller, the agent will represent only the buyer. Do not share any confidential information with this agent. And as you saw in the overview on the previous slide, underneath this section is a note to the seller, informing the seller that if they want additional information about agency types or about broker services or obligations, they can refer to that Q&A brochure that they can either get from the commission's website or from you. And then, of course, you want to ask the seller to sign the form, which again simply means it shows that the seller received the form from you. I can't emphasize enough the importance of you reviewing this form and not simply sending it to the seller. All right, so let's look at an overview of the buyer side of the form, and you'll notice that it's very similar to the seller side. It's got the same notice at the top saying that this form is required for all sales transactions, including commercial and residential. The title designates it as being for buyers. You've got the same important notes section there. And then you've got 4 categories of agency relationships that apply to buyers. And these are going to be similar, but not exactly the same as we saw on the seller side of the page. And then, of course, then below the agency types, you've got then a note to the buyer saying, basically, if you want more information about agency, here's a brochure, or here's access to a brochure that will provide more information. And of course, after you have reviewed this form with the buyer and answered any of the buyer's questions, you'll ask the buyer to sign the form, and you'll put your name and license number and firm name on it. Taking a closer look at the important notes section, it's exactly the same as on the seller side. It informs the buyer that it's not a contract, and that signing it simply means that the buyer is receiving the form. Everything else in this section is the same. The buyer agency types are obviously a little different. If you are communicating with a potential buyer and you're wanting to represent the buyer, this form basically tells the buyer, if you agree, the agent who gave you this form and the agent's firm would represent you as a buyer agent and be loyal to you. You may begin with an oral agreement, but your agent must enter into a written buyer agency agreement with you before preparing a written offer to purchase or before communicating an oral offer for you. The seller would either be represented by an agent affiliated with a different real estate firm or be unrepresented. Now, this situation would be where your firm only offers buyer agency, and well, what I mean by that is you're only going to check this one space if your firm is only going to offer buyer agency services. If you're going to offer, if your firm also represents sellers, then of course there are other boxes you're going to check on this form. But I want to go back to this sentence that says you may begin with an oral agreement. That's where you need to get an oral commitment from the buyer, where the buyer is saying, I want you to represent me. You cannot say, well, we'll talk about agency relationships and figure out who I'm going to represent later on. What you have to, the buyer needs to make an affirmative statement saying that he or she wants you to represent them as a buyer agent. You don't have to enter into the written buyer agency agreement at that point, but at some point before you actually write the offer, you do need to enter into that written buyer agency agreement. And if the buyer's not willing to do that, then you'll have to stop representing that buyer. So, okay, so that takes care of the buyer agency section. But let's assume for the moment that your firm also represents sellers and lists property. And of course, if your buyer client becomes interested in buying a property that your firm has listed, then you're going to talk to your buyer about dual agency. And as the form indicates, dual agency will occur if you, the buyer, purchase a property listed by the firm that represents you. And if you agree, the real estate firm and any agent with the same firm would be permitted to represent you and the seller at the same time. And it also talks about the dual agent's loyalty being divided, and indicates that the firm must treat both sides fairly and equally and cannot give one party an unfair advantage over the other. And just as on the seller side, if you've got a buyer who is uncomfortable with the divided loyalty aspect of dual agency, and if your firm offers designated dual agency, then you can offer this designated agency option and say, if you agree, then our firm can represent both you and the seller, and our firm would designate one agent to represent you and one agent to represent the seller, and each agent would be loyal only to their client. The statement below, you'll see an asterisk that follows both of the dual agency section and the designated dual agency section. And that's because it's going to be important when you enter into that written buyer agency agreement with the buyer. That agency agreement needs to include authorization for you to act as a dual agent. Now, I am aware that the exclusive right to represent buyer form produced by the NC Realtors does have authorization for dual agency and a request for designated dual agency. And so you want to make sure that if your client is willing to do dual agency, you need to make sure that the client has authorized dual agency in that agency agreement. And if they want designated dual agency, that provision has got to be initialed as well. Moving on to the final category in the agency relationships, when you're communicating with a buyer, this last category would be for seller sub-agency. This is where you as a broker are representing the seller, and an unrepresented buyer contacts you, possibly from your for sale sign on a property, or possibly you're doing an open house and an unrepresented buyer contacts you. And this form specifically instructs the buyer that the agent who gave this form to the buyer may assist the buyer in the purchase, but will not be representing the buyer and has no loyalty to the buyer. So, it indicates that the agent is only representing the seller and cautions the buyer not to share any information with the agent. And then, of course, below this section is a note to the buyer indicating that if the buyer wants more information about agency relationships, they can get the brochure from either from you or from the commission's website. And also, as we indicated on the seller side, you want to make sure that you get the buyer to sign it, date it, and then you're going to put your name and license number and firm name on the bottom of the form. You want to make sure that you give the buyer a copy of the form after the buyer has signed it. And by give, I mean either print a copy and hand it to them or send it to them electronically. The commission doesn't care how you do it, but you need to retain a record showing that you actually sent it to the buyer or the seller, whichever is the case. So just as the Real Estate Commission retains copies of emails when we send documents out, you need to create some sort of record system where you can show that if you send it electronically, that you've got a record showing that you sent the signed form to the buyer or the seller. All right, this form that we're talking about is available now. We encourage you to start using it as soon as possible. The deadline for using it is July 1st. So if you don't start using it before July 1st, you'll have to start using it on July 1st. And we encourage you to start using it sooner rather than later, so that if you come across any questions, anything you're not sure about, you can give us a call, send us an email, whatever. We're happy to answer those questions about it. If you're already working with a buyer or seller and you've already reviewed the old Working with Real Estate Agent brochure with them, you don't need to also review the new form with them. What you've already done is sufficient. It's just going forward with new potential clients, buyers and sellers, we would encourage you to go ahead and start using this form so that you'll be familiar with it. So what about the old brochure? What's happening with it? The commission has reformatted this brochure into a Q&A format with expanded content to fit in with the library of other Q&A brochures that the commission has. The commission encourages you to share this Q&A brochure with potential buyers and sellers as a supplement to the working with real estate agent disclosure form that we've been talking about. The rule only requires you to review the disclosure form. The rule does not require you to deliver the Q&A brochure, but we are encouraging you to share this brochure with potential buyers and sellers. We're also encouraging you to review it yourself. I think that you will find some very interesting information for your own education that will help. Just to touch on some of the content of the the revised Q&A brochure, it highlights the commission's commitment to racial equality and fair housing. It goes into detail about broker services and obligations and talks about how brokers get paid and who pays them. There are sections on the expiration and termination of agency agreements. And there also are diagrams for visual learners. And to give you an example of that, this is a diagram that appears in the new Q&A brochure. As you can see on the left-hand side of your screen, we've got broker A in red and broker B in blue to show that these two brokers work for two different firms. Broker A and his or her firm are representing the buyer, and broker B and broker B's firm are representing the seller. So you've got a typical co-broke kind of situation with two firms representing the two sides. In the center of this diagram, you've got two illustrations of dual agency. The upper illustration shows a firm and one of its brokers who is working directly with a buyer and seller. So again, you've got one broker working directly with the buyer and the seller, and that broker works for has one firm. The second, more common example of dual agency is where you've got one firm, but you've got two different brokers with the firm, and one broker represents the buyer, and broker A represents the buyer, broker B represents the seller, but it is traditional dual agency where the firm and all of its brokers are representing both sides of the transaction. And as we talked about before, some of your clients are not going to be comfortable with this divided loyalty. And that's where if you're offering dual agency, you can offer them that choice of creating the separation between broker A and broker B. As you can see in this illustration, there's a gap between broker A, who represents the buyer, and broker B, who represents the seller, so that broker A's loyalty is only with the buyer and broker B's loyalty is only with the seller. And it creates that separation that may give both the buyer and the seller some peace of mind. Keep in mind that when you do designated dual agency, you've got to have the consent of both the buyer and the seller. So you need to make sure that if one side, if the buyer says, well, I'm not comfortable with dual agency, I'd rather go with designated dual agency, you need to make sure that you go back to the seller and address the designated dual agency issue and make sure that the seller has said that, okay, that designated dual agency is okay. You've got to have the consent of both parties. You cannot do designated dual agency if one party doesn't want it. Let's see. So some of you may be wondering how these changes are going to impact the state license exam. And so Deb Carpenter, our education exam officer, will address that for us.
Thank you, Steve. I know that we have a lot of people on the webinar that are not educators. And so if you'll just take a moment, go to your happy place. I need to talk to my educators for a second. And so the first thing we need to let you know is, even though this form is available now, we are going to ask you to wait and start teaching in pre-licensing about the form July 1, when it actually becomes mandatory. That kind of helps clean things up for our new incoming candidates for licensure, so they're not getting confused with forms. Now, for the rest of you, you may have some candidates on the call, people who are in the process of getting licensed, as well as my educators who are helping teach these people. There's always this concern about, well, we had a new rule change, we had a new law change, we had a new form change. How's that going to affect the exam? The same way it always affects the exam. We only change the exam when the new law, rule, or form becomes law, rule, or mandatory. So on July 1, we will make certain that all of the items that have any reference to what will soon be obsolete, things like brochure, because it's not the Working with Real Estate Agents brochure anymore, it will be the Working with Real Estate Agents disclosure form, as Steve has been sharing. And there will be no more acknowledgement panel as effective on July 1. So any items that have those specific terminologies, those will be revised. It doesn't mean that there won't be questions about the Working with Real Estate Agents. It just means that it will be more specific and more appropriate to the language and terminology in play. And this is always the case anytime we change a law or a rule. So it should not be a huge surprise to anyone. And of course, Steve has been telling you to go ahead and start using this. If you're out there functioning in the real world right now, go ahead and get used to it. And I would encourage my people who are teaching post-licensing to go ahead and let the people in their classes be aware, go ahead and do conversations about the transition from the brochure to the disclosure form, and that the Q&A brochure will be a companion piece that is strongly recommended to be shared, because it does have a lot more of the content explained. Steve has done a wonderful job of expanding the content to be more user-friendly and more inclusive in the topics that concern the consumers. So for post-licensing, go ahead and put it out there. Pre-licensing, let's wait till July 1 and not confuse our people who don't even know that there is a previous version of the form. So that's what I have to say about that at this point. We'll welcome questions as we go into the Q&A section. Back to you, Steve.
Thanks, Deb. I want to add a few things, sort of announcements, if you will. Both of the Working with Real Estate Agent disclosure form and the Q&A on Working with Real Estate Agent brochure, both of those are now available on the Commission's website. The disclosure form is available under Publications and Disclosure Forms. The Q&A brochure is available under Publications and Q&A brochure. So two slightly different locations, but they're both under Publications. As you have been familiar with the old Working with the Real Estate Agent brochure being available in a printed cardstock version, the new Q&A brochure will also be available in a cardstock version. We're expecting delivery of that this week. So if you want to have some of those on hand, check with us in a week or two, and you should be able to order those if that's something you want to use. The Commission has ordered Spanish translations of both the disclosure form and the Q&A brochure. Those are in progress. I can't really give you a timeline at the moment for the Spanish versions, but just know that they are in progress. As Corinne mentioned earlier, a recording of this webinar will be posted on the Commission's website. And the information in this webinar will also be part of the 2021-22 Gen Up and Big Up courses. So you will continue to hear about this, for the foreseeable future. But again, feel free to contact us if you have questions. We're going to go ahead and open the floor up to questions, which you can post in the chat box. We've got 2 email addresses here. If you've got questions about the former rule after the webinar, you can send. And then, of course, questions about the exam or any instructional information, you can send to education by that email address.
Steve, there have been a few questions throughout the session, and I'm going to divvy them out to different people. You answered several of the questions already. I saw a number of people were asking what's the time frame on the disclosure form and the Q&A brochure, and as Steve told you, those are available now. If you go particularly under publications and to the Q&A brochures, there are 2 versions posted of that Q&A brochure that will be effective July 1, an 8.5 by 11 version, as well as the sort of traditional folded brochure. A couple of people have asked when is that going to be available for purchase? Very soon. So if you're wanting to purchase the finished product of the Q&A brochure, that should be out there and available for purchase very quickly, but you can go ahead and start printing your own copy of the 8.5 by 11 or the folded version right away. Those are available now. So let me go back, Steve. I think most of these questions were really more for Steve than Deb, but if there are a few that came in for Deb, I'll divvy those out to her too. Let's start out with, I saw this question in a couple of different ways. What if a client refuses to sign? What do you do?
Well, just as with the old brochure, just make a note that you reviewed the disclosure form with the client and that the client refused to sign, and put that in your records. I mean, obviously, you cannot make anybody sign the form. The whole goal is to get the information out there. If they refuse to take it, then that's their choice. And the commission basically just wants you to do your part. And if you make a note that you've done your part, then that satisfies the Rule A104C.
Great, thank you. Had a question about whether this also applies to commercial transactions. One person said, so the commercial brokers will be using this too?
Absolutely. Now,
Great.
It is quite possible that NC Realtors will, with the commission's blessing, create a commercial version of the form. I don't have any information on that yet. I certainly expect this form to be available in zip forms very soon if it's not already available. I think it's quite possible there will be a more commercial version of the form. And I think it's also possible that NC Realtors might create a version of the form that can be used in leasing transactions. But I do want to reiterate that the commission's rule only applies to sales transactions. So whether or not you choose to use a form in a leasing transaction is up to you.
Great, thank you. Now, and then that answered one of the other questions, which was, when's it going to be available in zip forms? So that will be coming soon. There were a number of questions about specifically the agency section of both sides of the form. So I'm going to try and break some of the categories of questions that I saw down. Number 1 question seems to be a question around who is initialing the form. So several questions were, what if the client or this consumer isn't even a client yet, hasn't decided what type of agency? How do we know what to initial?
Okay, well, as I mentioned earlier, the client is not making a selection with this form. The client is sitting back listening to you explain the different types of agency, and what you as a broker are doing are saying to the seller or the buyer, these are the possible agency relationships that could arise if we work together. If you're talking to the seller and the seller wants to sell and you're wanting to list a property, then you may only check that category that says, and if your firm only lists property and never represents buyers, then that first block may be the only one you check. You can initial it, check it. The form actually says check, but if you want to initial it, that's your choice. But for the seller side of the form, most firms are also representing buyers. And so it's very important that you address the dual agency type of agency relationship to make the seller aware that that's a very real possibility, that if you list the seller's property, or if you and your firm list the seller's property, that your firm might also procure the buyer. In fact, most firms want to sell their own listings. So it's quite possible when you have a firm that's representing sellers and buyers that you're going to need to check or initial, whichever you choose, both the seller agency side and the buyer and the dual agency side, section. And then if your firm also offers designated dual agency, you want to check that section as well. So the checking of the spaces is for you as a broker to say, hey, Mr. Seller, hey, Mr. Buyer, these are the possible agency relationships that could arise. This is not where the seller and the buyer make a choice. The seller and the buyer make a choice in the listing agreement or the buyer agency agreement. That's where they're making their choices. This form is just for informational purposes where you're saying, hey, these are the agency types that could occur.
That's great. And to follow, I answered a couple of questions in the Q&A that really follow what Steve just said. And that people were saying, well, what if someone's not ready to buy yet? Do we still have to sell? This is still the document that you provide to any prospective buyer or seller at first substantial contact. So this is still that same rule requirement of first substantial contact when you are dealing with someone who is interested at all in purchasing or selling. There was a specific question about designated dual agency, Steve, and I'm just going to read it. In presenting the designated dual agency part of the form, Steve said the firm could designate agents for the buyer and seller. The form says would rather than could. Would you elaborate on this?
Well, if one or the other party expresses reluctance about dual agency because of the divided loyalty, then the agent, the broker, should be offering designated dual agency if the firm offers that. And if the firm does offer that, and if that's something that both the buyer and the seller want, then the firm, with the buyer and seller's request, would designate one agent to represent the seller and one to represent the buyer. So it's all done with both clients have to authorize dual agency and both clients have to request designated dual agency.
Great, thank you. Just noticed that there were a few, at least one question from educators asking if they could start teaching this now. And I'm going to refer back to what Deb said, and that is if you're teaching a pre-licensing course, we ask that you wait until July 1st. But we encourage you as update instructors, as elective course instructors, as post-licensing instructors to go ahead in those courses and begin teaching this new disclosure form. Because as Steve said, the form is available now. You're welcome to go ahead and begin using it immediately. And you might as well go ahead and start talking about it in classes so that licensees know that. Let's see what else there.
Corinne, can I add something?
Oh, of course, please do. While I'm scrolling through, that will help me.
I was reading through one of the questions along that line, and I think some of the concern is if they're in a pre-licensing class that's going on now that will not terminate until after July 1, what do they do? Well, there comes a point where you just have to make a judgment call. Understand that we cannot turn on a dime and change the exam items and put in revised items, in the blink of an eye. What we can do is on July 1, remove anything that is controversial. So there is going to be a little bit of ramp up time to implement new revised versions of agency disclosure form questions. It doesn't mean that we're taking out all of the agency form questions. Don't get excited. There will still be some in there, but the ones that have anything that might be confusing to the student, that will be taken out immediately, and then we will be putting in the revised versions as quickly as they can get tested and certified. But we're good. Great. Don't worry about it. You're close.
Thank you, Deb. There is one question here. Did I hear correctly that this form is for sales transactions only, not leasing transactions? Yes, you heard that correctly. The Rule 104 subsection C specifies that this has to be provided and reviewed with all prospective buyers and sellers at first substantial contact. So residential and commercial buyers and sellers. Now you may be questioning this because, as Steve alluded to earlier, the Realtor organization did create a commercial version of the working with real estate agents disclosure that has been more appropriate for leasing transactions. So there's certainly nothing wrong with using the disclosure in those transactions. It's just not required by rule.
And if I may add to that, Corinne, the only time where disclosure would be required in a leasing transaction would be if a broker is working with a tenant, say, for example, and the tenant says or does something that implies that the tenant believes the agent is representing the tenant when the agent actually represents the landlord, then the agent would have a duty to explain to the tenant, no, wait a minute, I don't represent you, I'm representing the landlord. So anytime there appears to, where it appears to the agent that the tenant needs clarification, then the agent has a duty to explain to that tenant, no, I'm representing the landlord. But under normal circumstances, there would be no required agency disclosure in a leasing transaction.
Thank you. Several people have asked this question. On the current version of the publication, there's a checkbox about seller subagency. So the question now is, where does the unrepresented buyer initial that they agree to remain unrepresented and the broker is going to be a seller subagent?
Well, the buyer side of the form has the bottom category is for the unrepresented buyer. And that's to inform that buyer that the agent represents the seller. And so the buyer should be cautious about offering the agent any confidential information. The agent should be checking or initialing that section to highlight it for the buyer who they're talking to. It is within the realm of possibility, though, that after going some period of time without representation, that buyer may say, hey, I've had a change of heart. This transaction is going to be more complicated than I thought. I thought I could do it on my own. Maybe I really do need a broker. And then that's when you need to get out your buyer agency agreement and change the status of your relationship. So certainly it is within the realm of possibility that an agent may start out as a seller subagent and then change, but would have to change with a seller's blessing if the buyer has already entered into some kind of negotiation with a seller. Before that point, the agent could enter into a buyer agency agreement with the buyer, and there wouldn't be any conflict with the seller.
Great, thank you. There are a few questions that are generally around the topic of why we went with a single page that's double-sided, one for sellers, one for buyers, versus two separate documents.
Well, for simplicity more than anything else. I mean, if you're going to print a document, having one page is easier to keep up with than 2 pages. If you are doing it in digital form, either with zip forms or some other form service, yes, it's going to be two pages, but as brokers with all the pre and post licensing education that you've got, we believe that you are capable of explaining to a seller or a buyer, I've got a 2-page agency form I'm required to review with you. Only one side applies to you. We're not going to look at the second page. It's as simple as that. So it's just a matter of trying to keep it simple. The rule A104C refers to a publication, singular. So in an effort to try to change as little as possible, for those reasons, we chose to go with the one document, which digitally will have 2 pages, printed will have front and back of 1 page.
Great, thank you. I'm scrolling through. Actually, the way you answered that question answered several of the related questions there. Let's see. There are a couple of questions regarding whether or not the agency agreements are going to be updated. Obviously, those agency agreements are provided by NC Realtors. If, in fact, there are specific references to the brochure, then I would imagine those would be updated. I know that the Realtor organization is well aware of the changes in this disclosure form and hence will be updating soon that form in zip forms. I would imagine that any needed changes to agency agreements would follow. That said, the rule itself is not changing. The only real, the difference is a new document and the title, instead of brochure, we're saying disclosure form, but the requirement for disclosure has not changed at all. So not sure what is included on those agency agreements, but if there are those specific references similar to the license exam, those words will be changed, I'm sure.
Yeah. There's one question here. Can we print only the applicable side of the disclosure form? The answer is yes. You only have to print the side that you're going to review with your client. And of course, if the client's buying and selling, then obviously you need to print and review both sides. So one says, so at initial contact, does the buyer seller check all sections? The buyer and sellers don't check anything on the form. The broker is the one who's checking the sections that could be applicable to the buyer or seller. So again, it's just for informational purposes. Nobody's making any selections or choices on the disclosure form.
Thank you. I want to clarify, a few more questions have come up around that question of lease transactions. I just want to be clear that what we're talking about here with the Working with Real Estate Agents disclosure form, this publication is what is required to be provided to prospective buyers and sellers at first substantial contact. That does not say that no disclosure happens in lease transactions. It just means that this publication is not required. So going back to what Steve said earlier, there are certainly situations where you want to discuss and disclose agency in lease transactions. It's just that this publication is not required in those cases. We're not saying that disclosure itself is not required. We're saying that this disclosure form is not required.
And one person said or asked, did you say that tenants are not represented? No, I didn't say that. I said, if you're a broker representing a landlord and you're assisting a tenant and the tenant says or does something that implies that the tenant believes that you're representing the tenant, then you need to clarify for that tenant's knowledge that you don't represent the tenant. So it's all about, at that point, it's about disclosing a material fact. It's gone beyond the point of, agency disclosure. It's disclosing a material fact, because it would be improper for you as a broker to allow a tenant to continue thinking that you represent the tenant when in fact you represent the landlord.
Great.
Rand, there were a couple of questions on here about how their company changes from just offering dual agency to possibly doing designated dual, and or who designates. And folks, that's going to be your company's decision. So if you're an affiliated broker with a company, then you need to go back and talk with your company and decide what kind of agency options your company offers. And then they should also have a policy as to how designated agents are actually designated. That is not going to be your independent decision unless you are the sole practitioner all by your lonesome, and then you can't be designated against yourself anyway. So go back home and talk to the home people. X
you, Deb. See a comment, someone said, I just printed the Q&A from the website. It's tiny, tiny. Well, there is another version out there. There's the 8.5 by 11 version that isn't tiny, tiny. It might be easier to read. Also, I see a comment, if I have a Working with Real Estate Agent signed where the agent only checked buyer agency, then they end up in dual agency, do we need to change the Working with Real Estate Agents? Sounds like you need to change your process of going through the Working with Real Estate Agents disclosure form, because as Steve has said, what you are providing on that disclosure form are the agency options that are available. This is not the agency agreement where the prospective buyer or seller is making a choice. This is where you're giving them their choices. So this is where you're going to be presenting all of the options that are available, not just what they want.
Absolutely. So if your firm represents buyers and sellers, every time you review this form, you should be checking the buyer agency or seller agency section and dual agency. And if your firm also offers designated dual agency, you should be checking that section as well. So if your firm represents buyers and sellers, potentially you should be checking 3 of those sections every time you review the disclosure form.
Question at the end. I'm trying to make sure we don't miss any questions, but a lot of these have fallen into the same categories. One more question. If a broker checks all 4 sections on the buyer side of the form and the buyer chooses not to be represented, you seem to be saying that the check in the unrepresented buyer is sufficient disclosure for purposes of compliance with Rule 104. Yes. Is that correct?
I would agree with that, yes.
Okay.
The form adequately informs an unrepresented buyer that the agent who's delivering and reviewing this form is not representing that buyer.
Great. I am scrolling through. Deb, I know that you have been scrolling through also. I just want to make sure I haven't missed anything. Do you see anything that I missed? A lot of these questions.
One question, how does this apply to new construction sales agents?
Thank you.
It depends on whether they're licensed. You know, if a construction company is a corporation, then its true employees are not required to be licensed. And if they're not licensed, then this rule doesn't apply at all. If they are licensed, then they need to be delivering and reviewing the disclosure form with all prospective buyers at first substantial contact. So with new sales, it's a lot like doing an open house where you've got a curious buyer who walks in. The interaction may not ever rise to the level of first substantial contact. And if it doesn't, then it doesn't trigger the rule requiring the review of the form. But if while the buyer is in the model home or the sales office or whatever it is, if that buyer starts disclosing confidential information about what he or she is looking for and willing to spend and all that, then the licensed sales agent is required to deliver and review the disclosure form with that buyer.
I did find one more, Corinne. It was saying there's a statement on the disclosure form that says, otherwise, excuse me, the agent can share your confidential information with others. And how do we do that without creating distrust? It speaks to the fact that if the consumer that you're disclosing to chooses not to have you represent them, and they continue to share confidential information, and then they end up in agency with someone on an opposite side of a transaction, it speaks to that where they would have to share with their new client. So it's helping them understand, let's get everybody on the right team up front, know who's playing for whom, so that we're not giving away confidential information to the other side of the transaction. It's just the reasoning behind, please don't tell me things that you wouldn't want the other side of the transaction to know. Let's keep that private to yourself until we get our agency decisions made and the teams are all formed up.
Right. It's about creating an environment of trust, I think, because, you know, and where this is going to come up is if you go on a listing appointment and, you know, you go through this process of disclosing agency relationships. And if for whatever reason the seller chooses not to list the property with you, and then, you know, a month from now you're working with a buyer and you see that same property has come on the market, and in the listing appointment the seller told you what the seller was willing to sell the property for, and you notice that the list price is quite a bit higher, then of course as the buyer's agent you're required to disclose to the buyer, well, I know for a fact the seller has told me a month ago the seller's willing to take a lower price. Doesn't mean that today the seller is going to take a lower price, but a month ago, this is what the seller said. And it can certainly enhance the buyer's bargaining position. But if this agent who's now working with the buyer adequately informed the seller at the time of the listing appointment, then any information that the seller said during the listing appointment is fair game.
I think we have one more question. My office said that dual agency is only when one person is serving both seller and buyer. And if it is two agents in our office, then it is automatically designated. However, the form states that two agents in the same office could also be dual. How would you address this?
All right, well, what I want everybody to understand is in dual agency, it means that the firm and every agent with the firm represents both sides, okay? And that's where the divided loyalty comes in, because every agent with the firm is representing both sides. And so the designated dual agency option creates that separation between the buyer and the seller by authorizing the firm to designate one broker to represent the buyer, one to represent the seller. Now, your company can certainly have a policy where it decides which conditions it's going to do dual agency and which conditions it'll do designated dual agency. And the commission, the real estate commission, is not going to dictate what each individual company decides it's going to do. I mean, your company can decide it's never going to do dual agency, or that it's never going to do designated dual agency. I mean, obviously, I mean, as Deb mentioned earlier, if the firm's only got one broker, then they can't do designated dual agency. Or if the firm has got a broker in charge and a provisional broker, then the firm cannot do designated dual agency, because you can't have a provisional broker designated to represent one side if the other designated broker is the broker in charge. So those are the two examples where you absolutely cannot do designated dual agency. Otherwise, if a firm's got at least 3 brokers, there's no rule that would prohibit designated dual agency.
Great, thank you. All right, one final question, and then we'll wrap up, and we'll remind people how to send questions after the fact. Can you confirm that if I have a seller sign the seller's side of the form, and then they decide to use the firm, we do or don't have them go and sign the other side?
A seller never has to sign the buyer side of the form, and a buyer never has to sign the seller side of the form.
Great. So I think that addresses, I know that there were a lot of questions, but there were categories of questions. If you feel that you still have a question, then you can send those emails. Questions about the form, about agency options, about when to disclose, those can all be directed to Regulatory Affairs and the email address is regulatory-affairs@ncrec.gov. If you're an educator and you have questions about when you should start teaching this, where do I get the materials, or a little bit more about the exam, you can send that to the Education Division at educ@ncrec.gov. I just want to say thanks again to Steve Fussell and to Deborah Carpenter for their presentations, and to all of you for participating in the webinar today. It will be posted on the website. We wish you the best.